A coalition representing the biggest private equity and hedge funds is suing the Securities and Exchange Commission over sweeping new rules. The rules will require private funds to detail quarterly fees and expenses to investors and to perform annual audits. Firms also will be prohibited from allowing some favored investors to cash out more easily than others unless those deals are offered to all fund investors. The coalition is asking the Fifth Circuit Court of Appeals to vacate the rules, saying they're arbitrary and capricious and an abuse of discretion. Joining me is securities law expert Robert Heim, a partner at Tarter Krinsky Drogin. It's a 660-page rule. Tell us what it provides.
The new rules that the SEC adopted were designed to really fundamentally change the way that the private fund industry is regulated in the United States. In its adopting release, the SEC cited three basic concerns that it was trying to address, one of which was lack of transparency in fees and charges that private funds charge to investors. Another is conflicts of interest that the SEC was concerned about between the advisory companies and the asset managers that manage these funds and the investors themselves. And the third was a lack of governance at the private funds. So in the SEC's adopting release, which is over 600 pages, they set out some very substantive and extensive new rules that were designed to address these perceived shortcomings and problems in the private fund market.
Bob, so is it because the size of the private funds market has grown so much? They now hold more assets than commercial banks, and it's grown, according to SEC data, gross assets under management grew 171% from 2012 to 2022.
Yes, the rapid growth in the private funds market has been one of the facts that the SEC has cited for justification of its new rules. Right now, according to the SEC, there's over $26 trillion in assets under management in private funds, and the SEC used that as one of its basis for the concerns that it's expressed and the reason for these new extensive regulations.
This was adopted in a 3-2 vote along party lines?
Yes, that's right. These new rules are very controversial, both in the private fund industry as well as at the Commission itself. At the time when the rules were proposed and set for a vote at the Commission, it was passed on a 3-2 vote with two commissioners dissenting, and one of the commissioners, Commissioner Pierce, wrote a very stinging dissent from the rules, saying that they were ill-conceived and that they were going to impose a lot of costly burdens on the industry, and also criticizing the majority of commissioners because, in her view, the rules really were not justified. Commissioner Pierce also cited this statistic of over $26 trillion in AUM in the industry and said that, in fact, that shows that the market is very successful. The investors that invest in private funds are very sophisticated institutional investors. They're advised by the world's top law firms. And if there really was a problem in this market, it's really hard to explain why the private fund market would be growing so rapidly. And investors have been enjoying, significant returns and profits on their investment, which these rules will, cut into as a result of the high cost of implementation.
These rules are watered down, right, from what the SEC originally wanted?
Yes. In the proposing release that came out several months ago, the SEC had originally proposed even more stringent rules and stringent prohibitions. And due to the backlash and the comments that were submitted by investors and industry participants, the SEC changed and watered down some of these rules. But the final rules were still, quite strong. And I think, what's concerned Commissioner Pierce and others in the industry is that really the argument here is that the SEC overstepped its statutory authority. Its justification for adopting these new rules was based on a provision that's the general anti-fraud provision in the Advisors Act statute, as well as a short provision in Dodd-Frank that was really geared towards retail investors and regulating retail-oriented investment funds. And the biggest complaint of the industry, they've gone to court to challenge these rules, is that the rules outright prohibit a lot of activities and contractual terms that are very commonplace. An example of that is certain large investors get preferred information rights. They can negotiate certain provisions with advisors that would allow them to withdraw their funds in a shorter lockup period than other investors. And that's just a fundamental characteristic of the private funds market, that you can have these customized terms. But the SEC said essentially that can no longer happen. You can't have negotiated terms like that.
Lead plaintiff's attorney Eugene Scalia wrote in the lawsuit, quote, "The rules exceed the Commission's statutory authority, were adopted without compliance with notice and comment requirements, and are otherwise arbitrary, capricious, and abuse of discretion and contrary to law." He got everything in there. Did they not have notice and comment on these?
Well, they actually did have notice and comment, and it was quite a long and detailed notice and comment procedure. What the industry is complaining about in that particular section is that the final rules that were adopted by the SEC are so different than what was originally proposed, is that in effect that the notice and comment period was not sufficient. They're arguing in the industry that once the Commission changed the rules to such a great extent, they should have undergone another notice and comment period so that the industry and others could comment on these new proposed rules and hopefully, convince the SEC to roll them back even further.
Drew Maloney, chief executive of the American Investment Council, told the Wall Street Journal that the rules will discourage competition, harm investors, reduce returns, stifle innovation, and impose costly burdens on funds of all sizes. Do you agree with any of that?
Well, I do. I think that there's no question that the rules themselves are going to be quite costly. Even in the adopting release, it's acknowledged by the SEC that it's going to cost billions of dollars industry-wide to comply with the rules. And the argument is that this really falls most heavily on the small advisors or new advisors that want to come into the space, and essentially the cost associated with compliance is going to be prohibitive. But I think, one of the main points of the industry, too, is that it really questions the role of the SEC in the sense that for years, the industry, which is made up of these institutional investors that are very sophisticated and private fund managers, have been going along fine in terms of negotiating contract provisions that were customized to their own individual situations that were structured in that way. And the SEC has now stepped into the picture and said, no, we know better as the SEC what contractual terms should be in place, and the contractual terms that you've been negotiating all along, those are no longer going to be permitted because, we have decided to fundamentally change the way this market is regulated. And the industry is saying that the SEC has no statutory authority from Congress to step in and make that unilateral determination.
SEC Chair Gary Gensler said he feels very confident in the agency's conclusion that it does have the power to implement the rules. What's your take on it? Does it have the power?
I think that's going to be a tough argument for the SEC. The industry challenged the rules in the Fifth Circuit, which historically has been somewhat hostile to the SEC's expansive claims of regulatory authority. So the industry, made a smart decision in terms of the forum that they've decided to challenge these rules in. And in the adopting release, the SEC really just pointed to some very general provisions. The anti-fraud provision is one basis, and another provisions that related to requiring the SEC to provide enhanced rulemaking so that advisors would have to be clear about the terms and conditions of their relationship with investors, which was contained in the retail regulation section of Dodd-Frank. And traditionally, federal courts in the last several years have been hostile not only to the SEC but to other agencies who claim these, broad-ranging powers to regulate industries that, in a lot of respects, are hard to tie into the congressional grants of authority that have been made to the agencies.
Coming up next, I'll continue this conversation with Robert Heim, and we'll talk more about why this suit was filed at the Fifth Circuit. Lawsuits challenging the SEC rules are filed directly to appeals courts, so they skip the lower district court. And they went to the Fifth Circuit, as you mentioned, which is the go-to venue for conservatives and business groups challenging regulatory authority and ranging from the abortion pill, which is still in litigation, to the SEC's in-house courts.
Yes, that's correct. The Fifth Circuit in particular has been very open to constitutional-based arguments from business groups and private parties to really look at what agencies are doing to make sure that it's constrained within their statutory authority. And this is really a fundamental principle in the Constitution in terms of, in the democracy, our elected representatives in Congress are supposed to make laws that people can vote on. And then there's a narrow delegation to agencies to implement those laws. But here, for example, with the SEC's regulation of the industry and these new rules really didn't go through a democratic process. It was just something that the agency decided, in their view, needed to be done and impose these rules. And that's the argument from the industry. We're going to have to see if the judges in the Fifth Circuit accept that, and that's going to be their decision as to whether or not these SEC rules come within the statutory authority in the Investment Advisors Act to allow the SEC to implement these sort of changes and rules.
It's been sort of a regulatory blitz by SEC Chair Gary Gensler that we've talked about before. Is this just one step too far?
Yeah, I think that's part of the analysis. One of the concerns that Commissioner Pierce had, that the industry has as well, is that when the SEC conducts its statutorily required cost-benefit analysis of the new rules, they look at each rule, one by one, and they say, what's the cost and the benefits of this particular rule on the industry? But the point that the industry is making is that that's not always the best way to look at this, because the SEC has been engaged in a lot of new rulemaking. It seems like every week there's a new rule that comes out, and the industry is saying that it's not sufficient just to look one by one. You really have to look at the whole basket of rules that the SEC is coming out with in lots of different areas when you look at the sort of costs that are being imposed on the private sector and whether the rules are really going to provide the investor protection benefits that the SEC claims that they are working towards.
Are these cases different in that this is a really wealthy and powerful industry that the SEC is going up against?
Well, it does make a difference in the sense that the challenge to these rules is certainly a well-funded effort. The lead lawyer, Gene Scalia, who's the son of Justice Scalia, the late Justice Scalia, is probably the top lawyer that the industry has used to challenge various regulations, not just at the SEC, but at the EPA as well, on the argument that the rules exceed statutory grants of authority. But I think it's also a more fundamental point. The industry is arguing that Congress deliberately set up a two-part regulatory system. One is mutual funds, which are regulated under the Investment Company Act, which has extensive disclosures and substantive rules that are appropriately in place to protect private retail investors. And Congress made a conscious decision to not impose that extensive regulatory regime on private funds, which are open only to very high net worth investors and institutional investors. And Congress basically left it up to the parties in that scenario to negotiate contractual arrangements regarding fees, regarding investment objectives, and what duties the advisor owes. And what the SEC has done with these rules is blur the distinction between those two regulatory regimes and is really importing these extensive regulations from the mutual fund space onto the private fund space in a lot of respects.
If there is an adverse ruling to the SEC, does that have implications for other areas the SEC is regulating?
It won't have a direct implication for other rules that the SEC is making, but in a certain sense, it really, from a practical perspective, makes the agency sit up and take notice to really understand that courts are going to be scrutinizing their claims of statutory authority and perhaps gives the SEC more reason to pause its rulemaking and not be so aggressive in the future with regards to the type of rules and changes that it imposes on the industry.
Bob, was the SEC sort of prepared for this lawsuit?
The SEC really understood that they were going to have a challenge of these rules in court, and the adopting release has quite an extensive discussion by the SEC as to what its claims of statutory authority are. And in addition to going through the two statutory provisions in the adopting release, the SEC goes to great lengths to really try to explain that it's not really just institutional investors that are at stake here. The adopting release talks about that it's pension funds and endowments, and indirectly those pensions are made up of civil service workers, firemen, police officials, teachers, community activists, and the SEC goes through a whole description in their adopting release as to how these everyday types of people are impacted by the private fund industry and the types of rules and regulations that are imposed on it. So, the SEC knew that this challenge was coming. They've done, everything they can to prepare for it. So it's going to be very interesting when the court addresses this. The parties have proposed a time frame that would allow the Fifth Circuit to issue a ruling by May 2024, which is several months before a lot of the final deadline for when these rules have to go in effect.
So a long road ahead. Thanks so much, Bob. That's Robert Heim of Tarter Krinsky Drogin. Coming up next on the Bloomberg Law Show, class action lawsuits against pharmaceutical companies and retailers over ineffective decongestants. We're approaching cold and flu season, and the Food and Drug Administration has said the leading over-the-counter decongestant used by millions of Americans looking for relief from a stuffy nose is no more effective than a placebo. Advisors to the FDA voted unanimously last week against the effectiveness of the key drug found in popular versions of Sudafed, Dayquil, and other medications stocked on store shelves.
This ingredient, phenylephrine, is in so many different cold medicines. That's why it is important to kind of educate yourself on what to look for and just avoid that ingredient.
Dr. Purvi Parikh, an allergist at NYU Langone Health, recommends reading the labels of these products and choosing something else instead. It didn't take long after the FDA's announcement for several class action lawsuits to be filed against pharmaceutical companies and retailers. My guest is healthcare attorney Harry Nelson of Nelson Hardiman. Harry, first tell us about this board of advisors and what they decided.
Yeah, it was an FDA advisory panel that finally came out with a statement that people studying phenylephrine have been talking about for a while, which is that it is not better than placebo, that essentially it's ineffective. When taken orally, it does not actually function as a decongestant, and little of the drug actually reaches the nose to be a decongestant. It's effective when it's used in a nasal spray directly to the nose, but the problem is that we sell billions of dollars of these different decongestant drugs where people take it orally, and it has absolutely no effect. It's completely broken down in the stomach.
So you mentioned this, but there have been decades of studies and questions and documentation and clinical trial results. Why did it take so long for them to come to this conclusion?
It's a good question. It's kind of an indictment, honestly, of the FDA's ability to do serious review. There were studies being put forward and petitions made to re-examine it, but when you go back and look at what was happening, for the last 20-plus years, it's been a process of rubber stamping and ignoring what's been said. It was a glacial pace, and it took an enormous amount of time for peer-reviewed studies to actually be given the attention they deserve. So it's kind of an indictment of the FDA process, that it took this long to see something that was quite obvious to people who were studying it.
And the decision is confusing to consumers because shouldn't ineffective drugs be taken off the market and replaced? But here they're saying, no, you don't need to throw away these products.
No one is saying these products are dangerous or that phenylephrine causes harm. They're just saying it's ineffective. It's not better than placebo. So there's no danger associated with using these products. They're probably just not the best choices to use if you need an effective decongestant.
This is just an advisory opinion. The FDA doesn't have to go along with it. And now what happens? They're going to allow the public to comment. What good does public comment do on an issue like this? I don't get that.
Yeah, it's a fair question. It's not at all clear what public comment is going to add to the conversation here. It just seems like they're still continuing to go slower than you would hope once we've kind of finally come to this public realization that there's a drug that's not working on the market, and people are spending a lot of money on it.
What does the FDA have to do now in addition to, we mentioned the public comments, but what has to happen next?
The next step is actually formal. This was just an advisory panel, but the FDA has to formally review the status of the drug and presumably revoke its approved status or narrow its approved status because, again, the drug is useful when applied directly, for example, like through a nasal spray, but at least orally to revoke the approval of the drug.
How unusual is it that class action lawsuits were filed within days of the FDA's announcement?
So, it's almost reflective, right? There are plaintiff law firms around the country that are basically built to take on harm related to different drugs. And so as soon as the FDA said this drug was ineffective, it's not a surprise that we saw this first class action filed down in Florida. I'm sure we're going to see more. The real question is, other than the harm to people's wallets from spending, $1.75 billion on this drug, what actual harm, whether there were any side effects that actually hurt anybody from phenylephrine. There's a lot of reports of minor problems like swelling or skin rashes and itching, but I'm not aware of any severe harm, and it's not clear what kind of damages there are going to be beyond just the fact that these companies were selling an ineffective drug.
Some of the complaints charge that the defendants violated consumer protection statutes and alleged a breach of implied warranty of merchantability, and they committed fraud, stating the defendants intentionally and knowingly falsely concealed, suppressed, and or admitted material facts, including as to the standard, quality, or grade of the products they marketed and sold. But if the FDA approved this, what were the manufacturers supposed to do? Say, no, the FDA is wrong?
There's been a lot of industry studies going on. So we know that, for example, competitors of some of the phenylephrine products, like the folks at Schering-Plough, who were making Claritin, were doing a lot of research to show that and arguing that these drugs were ineffective. It's an interesting question whether internally, whether the manufacturers were doing their own research and had reason to know that these drugs were not effective and whether they turned a blind eye to it. I think it's an interesting question, and hopefully we'll learn about some of the internal process within the pharmaceuticals and how much they were aware of this and taking it seriously and concerned about it. But, I think that still remains ahead of us.
You mentioned harm to consumers and that there's probably very little of that. So it would be limited to economic damages, right? How would they determine the economic damages to consumers from this?
I think what's likely to happen, I don't mean to sound cynical, but when this case gets prosecuted, what's likely to happen is that the lawyers who brought these cases will have a multi-million-dollar payday in attorney's fees, and there'll be coupons, for people who can prove that they bought the drug. But those coupons will be for insignificant amounts. The big winners in this class action are likely to be the lawyers who get tens of millions of dollars for filing it.
As an example, Johnson & Johnson's consumer unit settled claims alleging aerosol products contained benzene for $1.75 million plus $2.5 million in attorney's fees. So more in attorney's fees than in the settlement for consumers.
Yeah, so a lot of people, including me, think it is a defect in our class action system that, the plaintiff class action lawyers are motivated to bring cases that really don't do much to advance the public interest, but do produce profitable work for them. Kind of a sort of bug in our class action system that anytime there's a drug, even if the harm to the public is really minuscule, the plaintiff class action lawyers have a big opportunity.
Are those kinds of suits mostly settled? Do any of them ever go to trial?
This is certainly not a case that's going to trial. This is clearly, if there were big damages and significant amounts that would be at risk, like if the harm caused by phenylephrine was so significant, then there would be something to fight over and a lot at stake. But, the money that the drug companies are likely to pay for this is going to be something like a rounding error for them. This is not going to be one of those multi-billion-dollar settlements. It's likely that the plaintiff class action lawyers will kind of have a get in quick, reach a settlement, and the drug companies will be offered numbers that will motivate them to do so. I think it's a pretty safe bet that we're never going to see a trial on the marketing of phenylephrine.
Does the FDA give the drug manufacturers time to put new products on the shelves, or don't they take that into consideration?
The first decision is whether to actually revoke the marketing approval for it. But if the FDA imposes a recall, the recall is focused exclusively on the public health issues and not on whether these drug companies have time to find alternatives. That's really the drug companies' problems. I'm sure that the folks at all the companies that were selling phenylephrine are already working hard on that. But the really interesting question here is whether the fact that the drug is ineffective, though not seemingly dangerous, is going to provoke an actual recall, or alternatively, whether presumably its sales will decline. The drug companies will obviously stop marketing it because, now that the FDA has come out with this, it's a much higher risk for them to engage in any marketing suggesting that it has positive benefit, and whether it will just fade away from the shelves of our drugstores sort of more naturally.
I sort of assume that the FDA, in light of this, would take these off the shelves at some point, since the best you can say is they're ineffective.
Honestly, I think the reason that phenylephrine became popular in the first place was because of problems associated with a different decongestant that is effective, which is a related drug category called pseudoephedrine. More than 15 years ago, we started seeing that methamphetamine dealers or manufacturers were using pseudoephedrine to make illegal drugs, and so that led to the popularity of phenylephrine as an alternative. So I think now it's kind of back to the drawing board of actually figuring out what are going to be effective decongestants, and it's going to be interesting to see what the impact on pseudoephedrine access is, given that it is an effective decongestant, but also a drug that is at risk of abuse. That's a part of the story that we haven't really been talking about yet, but I think it is clear that part of the rise of phenylephrine was about the problems associated with pseudoephedrine. So it's going to be interesting to see what medications are the winners after phenylephrine fades from the market.
Thanks so much, Harry. That's healthcare attorney Harry Nelson of Nelson Hardiman.